present in the virtual courtroom. We have both parties as well as their respective attorneys. We are here on the plaintiff father's motion for a temporary order. Mr. Spanaki.
Thank you, Your Honor. There might have been a motion today where kids are in crisis. That's not this case. You might have had a motion this morning about parents causing problems for their kids. That's not this case. You might have even had a case with a mother who's trying to steal someone's baby from the mother and deny her all her rights as a mother. That is not this case. We have both filed documents to show you these are wonderful, thriving children, very loving and involved and well situated in their schools and community and their activities. And they're just great kids. And I used to have a t-shirt, great parents or make great kids. So I think there's something to do with that these parents have done a good job with these two kids, a 10th grader and a 7th grader, both girls. Both these people, I'm sure, suffered in their own ways some unhappiness for years. In March, at a counseling session, father said, I can't do this anymore, and we're going to have to process a divorce. Mom doesn't want the divorce. In May, he found a home less than 6 miles away. The school is in between the two houses. It's brand new construction. The kids have their own rooms. There's a fully stocked bathroom, a fully stocked fridge. There's desks and chairs and thermoses and lunch boxes and everything else. So,
all right, guys. Today we are stepping into a courtroom where everything sounds calm on the surface, but the stakes are already sky high. This opening may feel procedural, but it quietly sets the battlefield. A father seeking temporary orders. Two parents on opposite sides of a future they no longer share. A judge preparing to weigh children, money, and control. This is the calm before the collision. No accusations yet, no emotions spilling over, but you can sense it coming. Every custody case starts like this, orderly and restrained, right before reality crashes through the legal language.
We have a good situation set up. Mr. Vanderwerf has tried to get some kind of parenting plan set up. In May, mom said, well, let's wait till the summer. In the summer, there was just a series of excuses, delays, cancellations. Mr. Vanderwerf was saying, can we talk about this? And Mrs. Vanderwerf, I'll read you a couple of the texts, but she wasn't cooperative. He asked, well, maybe we should meet with a mediator. She wasn't cooperative. She said, having them stay with you isn't something I've agreed to yet. That was in June. Then there's just these things. Well, that won't work. Tomorrow would be better. Sorry, we're out. We ended up out. I'm in the middle of something. Tonight won't work. I'm okay with the girl spending the day with you. I'm okay with you having dinner with this one daughter. You can come to the house on Tuesdays and Thursdays at 7:30 p.m. and spend time with your daughters. So that's kind of how this went. We drafted a full proposal. Part of that was because the largest single asset is the home, the marital home with 450,000 or so equity. We'll find out. And we understood that Mrs. Vanderwerf wanted the home. The only way she can realistically keep it is to do a buyout. And but we'll figure that stuff out. So the main thing for the parenting is at this point, Mrs. Vanderwerf says, well, let's wait till the end of November. You know, we have to start something. If mother had said, let's start the phase-in with what she calls phase 2, which is every Wednesday overnight and the weekends from Friday to Monday. And if she had said, we'll do the 2255, but not till January 2026, we wouldn't even be here. But they couldn't do that, so we need to get this going. We provided as our Exhibit 1 a fully laid out 2255 parenting plan with holidays and everything else situated. We have Exhibit 2 is the Michigan Child Support Formula calculation. The claim was father hasn't provided any money to mother. At the beginning of this year, there was more than $46,000 in a money market. Now there's 10,000. Where did the money go? Father used 5,000 for a down payment. Mother took 30,000 out. She tells the court that her income's just over 30,000. It's actually 34. We know that because now she says she gets 2,000 for coaching. And she told the insurance company when she signed up for benefits through the school that she was making over $32,000.
Buckle up, guys, because this is where the father's side builds momentum fast and deliberately. The argument is clean, confident, and calculated. We're told these are thriving kids, a responsible father, and a home already prepared for stability. Then the tone shifts. Cooperation was requested, delayed, denied. Text messages start to matter. Timelines start stacking up. Money starts disappearing. Parenting plans stall. This isn't just about access to children anymore. It's about control and credibility. By the end of this stretch, the message is clear. Delay has become a weapon, and patience has run out.
But we calculated her at 32. We didn't calculate the 2,000. And that ends up being $812 a month. Her shortfall on her budget, which doesn't include a mortgage or a car payment, she gets health insurance through work, includes some fluff, but just looking at her budget, she says she has a shortfall of $380. Well, she's making over 3,000 more than she puts on her budget. But we'll figure the spousal support part out later. And I think either the house is going to end up being sold or we'll do a buyout of spousal support. But for now, hitting the $812, starting up the 2255 gets her budget covered because 812 minus 380. I mean, she's got money left over. We also had Plaintiff's Exhibit 3, which is the mutual restraining order. I understand that from counsel's submission that's fine. So that's what we're asking for, is to go with the full plan that we laid out, the child support that corresponds with that, and the mutual restraining order.
Thank you. Ms. Rademacher.
Thank you, Your Honor. Your Honor, we aren't dealing with a 6 and 8-year-old, which pretty much just go where they're told. We're dealing with a 12 and 16-year-old that have lived in this marital home their entire lives.
All right, guys, now comes the emotional counterpunch. The mother's side reframes everything through the children's lens. These aren't toddlers, they're teenagers with routines, memories, and opinions. Dad travels. Dad works late. Dad moved. Suddenly, stability becomes the key word, not fairness. There's subtle character damage too, missed events, divided attention, questionable priorities. The courtroom tension rises because this argument isn't about numbers or schedules, it's about identity and guilt. The phrase, "play house somewhere else," lands heavy. This is the moment sympathy is deliberately pulled toward one side.
Mostly with mom, because mom was a stay-at-home mom for about 14 years. Dad travels, so he's in and out of that residence and was about a week a month. And he works West Coast time, so even when the kids have spent time with him, his schedule is such that it's 3 hours. So they're home in the evening with him, but he's still needing to work. So the children have the main custodial environment, and the status quo is, and their ages dictate that they don't want to play house somewhere else. Just because dad wanted to move doesn't mean that they want to move as well. Now, that doesn't mean that they don't want a relationship with their dad. The parties have cooperated and orchestrated continuing contact with the children. A lot of Mr. Vanderwerf's contact with the children was directly arranged between him and the children. So that's the schedule that he developed with them. In addition, like this August, September, he spent a lot more time with the girlfriend that now we've discovered he has. And he even no-showed for their daughter's dual cross country with no text, nothing. So his mindset's a little skewed right now. We do have to get this case on schedule, but not because he wants to play house somewhere else. We need to honor the custodial environment that these children have. And that is why I have that phase 1, phase 2 schedule where it's a pattern that we're establishing. Kids, Wednesdays are dads. Weekends, every other weekends are dads. We'll start keeping you at home on the evenings, but start getting used to the environment at dad's and being prepared for school in the morning and so forth. And that's why in phase 2, we can go in quickly within a 30-day cycle into a Sunday overnight and then the Wednesday overnights. This is very much.
Buckle up, guys, because this short moment quietly flips the emotional script. With surgical precision, the father's side dismantles the house versus home narrative. It's not the walls that raised these kids, it was the parents. And now there will be 2 homes, whether anyone likes it or not. This isn't loud or dramatic, but it's powerful. It reframes comfort as adaptability and love as presence, not location. In just seconds, the emotional argument loses its footing. The court is reminded that nostalgia cannot override reality.
Taking into consideration the reasonable preference of the children. It was stated that the children wanted 225. That is absolutely not what has been happening, nor is what we're hearing. I think these kids are being put in the middle, feeling perhaps guilty. I don't know. But the bottom line is if we look at the pattern since May, these children continue to stay and have their routine, a 12 and 16-year-old in the marital home. And that's what is comfortable for them. And we can start with this transition, phase 1, phase 2, as I've indicated in my motion. The text that I heard, I asked my client, I believe they're taken out of context. And it is truly just working towards something. You know, these parties have never been divorced before. They don't know. As far as the financial situation, my client handled all the household bills in the house, and she transferred because Mr. Vanderwerf no longer deposits his check into the party's account from which he supported the family. And so he left the money market account for her to use, and she would transfer it to pay the bills. That's what she's done, and that's why it's dissipated. So we need to stop that bleeding, and that's why once we establish the child support, that will help. And the spousal support, I'm looking at a difference of him making $140,000 a year and her about 32. There's certainly a disparity. I don't think she has to live dollar to dollar. That's not fair either on this 28-year marriage. So if we look at the schedule that I've proposed, and I attached my child support guidelines as well, that leaves a child support amount and a significant amount that I believe also does meet the budget for now. And we can reserve spousal support while we work out the rest of the details, as Mr. Zarnecki said.
All right, guys, this is where the courtroom stops debating and starts deciding. The judge acknowledges the pain, especially for teenage kids, but then delivers the hard truth. 6 months have passed. This family cannot stay frozen in denial. The Band-Aid analogy says it all. Slow transitions sound gentle, but sometimes they prolong damage. Phase 2 starts now. No easing in. No more waiting. This is the moment authority replaces argument. You can feel the shift as emotions give way to inevitability. The direction of this case is now set.
We don't include, keep in mind that their oldest son, Sam, who's 19, he goes to college in Albion. Mom has helped him in the past with tuition and things of that nature. He comes home from school, and the parties are going to just have to continue to agree on those additional expenses, which are not in this budget. So, Your Honor, this isn't a tug of war, and that was kind of my point of my little epitaph in the beginning of my motion, is that we are dealing with real children, girls who are young adults that have their stuff. that have a routine, that love their family and want to do this in a methodical way, that they do not want to have complete disruption of their lives, living in two different, one on one side, one foot on the other. That is not fair to them. And that's why we asked the schedule that we did. I'd ask the court to adopt my child support number because that would balance the budget as well as take into consideration the flexibility that I think will occur. And the mutual restraining order, I don't object, of course. To the assets, I think Mr. Zarnecki put in there something about the harassing and that type of thing. I don't think we need a behavioral restraining order, but I'll leave that to the court's discretion, but no objection to a mutual restraining order regarding assets. Thank you.
Mr.
Yeah, I would
Sarnacki.
just like to add one comment, and I heard this is the only house the kids have ever known. They don't want to play house anywhere else. Mr. Vanderwerf wants them to play house somewhere else. There's a difference between a house and a home. These children will have two homes wherever the parents live. So let's just get off of that idea that this brick and mortar makes the difference and made these children great. It was these parents working together. Thank you.
All right, thank you. I heard an agreement regarding a mutual restraining order regarding assets.
Buckle up, guys, because this is the financial and legal wrap-up where consequences lock into place. The judge cuts through income disputes, accounting differences, and hypothetical arguments. Temporary child support is set. Spousal support is reserved. Custody is joint. The house goes to mom for now. Nothing here feels dramatic, but everything here matters. These numbers will shape daily life. This structure will define power going forward. And with that final procedural close, the courtroom reminds everyone that feelings fade, but court orders don't.
That certainly can be implemented as an order. And Mr. Sarnacki, you didn't really respond to the behavioral part of a mutual restraining order.
Well, I don't know what the harm is in telling people not to harass each other, but you can decide that, Your Honor.
Okay, all right. Let's leave it out for now. I hope it won't be necessary.
Okay.
Because I'm not hearing a strong argument in favor. So, all right. As far as the parenting time, I understand this is difficult. It's difficult for the parents. It's difficult for the kids, especially difficult for teenage girls. Teenage boys probably would have similar issues. It's really crappy to have your parents get a divorce at any age, but certainly at this age. So I get that. But to counterbalance that, this family, it's been 6 months. And this family needs to start moving on and accepting kind of the reality of what's happening, and that there's a new reality, which involves two parents in two separate homes. Uh, so, um, but again, trying to take into consideration these children's natural feelings and reluctance for things to change. But the court finds that implementing phase two right now is appropriate in this case. Phase two was proposed by Ms. Rademacher as opposed to having a phase one then a phase two. Just because at some point this Band-Aid needs to be ripped off. And I realize phase one was proposed to be a fairly short period of time, but I think given the amount of time that's gone by, let's just start with phase two. The court will grant the mother exclusive use of the marital home. And I'm sorry, Mr. Sarnacki, what was your position regarding the spousal support?
Well, what I heard Ms. Rademacher say is that they want to reserve it, and I'm fine with that.
Okay, what about the child support?
Well, I think the child support that they're asking for is excessive because their budget underreported income that they've already admitted to the benefits department. And probably included all kinds of other things. But, if we picked a number in between, we can deal with that on the back end of the case. I don't remember what counsel's.
Can I ask what under reporting of income are you referring to?
She said she makes 30,000, but when she applied for the benefits with the National Services insurance or whatever, she wrote down over $32,000. Then she also that was for her salary. Then she also has now apparently 2,000 for cross country, so she's up to 34,000.
Okay, so I can tell you that the hourly rate she makes, and she doesn't get paid year round either, is exactly the amount on my child support guidelines of her salary. And then you would add $2,000 to that. So 32,843 is what her, I use 2,000 for her, coaching, and then how much per hour? I've got it right here. She makes $20.84 an hour. And then she doesn't get paid all year round. So if you average that all out, that's where you get that 30,800.
Under penalty of perjury, she told the National Insurance Services that as an administrative assistant, she makes $32,177 working 40 hours a week.
Well, let me just interject a minute here.
It's not that far apart.
No, that was going to be the point that I make, and it's got to be a pretty significant bump in income for it to make a huge difference in the child support formula, as we know.
Right.
But this is only a temporary order, so I think $1,600 a month in child support and reserve on the spousal support is appropriate. And then that can be, retroactively modified depending on the proofs or the party's settlement.
Okay.
So we have legal custody, physical custody, and the 2255 question.
Well, at this point, joint legal and joint physical is appropriate. And then the 2255 question, I think, is something that the court can look at going forward. We will implement the phase 2 and see how that goes. And then with the idea that maybe phase 3 would be something like a 2255 if everything goes well.
Okay, thank you, Your Honor.
Anything else?
I'll prepare the order. Thank you.
All right. Thank you. And we're